Are you guys here just for the H3 and what do you, H3 through 7? I think those water one's gonna take a while, so I'd like to get you guys taken care of it.
What about H1 and 2?
Yeah.
I mean, you guys have
H1 was removed from the agenda this morning at the time of additions, deletions from the agenda.
H1?
H1 was, yes, sir.
Well, H2 is the one I'm here for.
Very good.
Okay, that'll be it. So, okay, we're gonna take up H2. Rachel, you wanna do that, Mr. Chairman?
See?
Yeah.
Mr. Chairman, members of the biomass community have requested that the board through you take a position opposing SB 1139, which would require utilities to procure a certain percentage of geothermal renewable power as opposed to just renewable power. Their take on it is that, you know, that would come at the expense of the biomass industry. Utilities are forced to use a certain percentage of geothermal power, and to that end, they view the biomass industry in our county as being important and worth supporting, or at least keeping on a level playing field with other forms of renewable energy. So we proposed this draft letter that I've included in your packet, and it speaks for itself.
Okay, thank you.
Before we move on, I just have one correction if I could, is asked that we add in the title where you have all the people that are sent to, there's a space here. Could we add Brian Dolly to that?
Sure.
He's not a member of the Assembly Appropriations Committee. Obviously, this is targeted to go to the Appropriations Committee because that's the next committee. But I know he's been working on and speaking on this bill from the get-go. And I think as a matter of courtesy to him, we ought to let him know what we're telling these other people. Because, you know, if we've got a message that's different from his message, or if it complements each other, he needs to have that heads up, so we can include him as an addressee.
Okay, very good. Okay, is there any questions of the board of the letter? Mr. Chairman?
Yeah, I have a question. That biomass plant employs 30 people in our county, and we definitely want to protect them as much as possible. But also, we have a resource in this geothermal energy that's probably second to not many, that we haven't even really begun to explore. And I really believe this is kind of a double-headed coin for us. I think we have a lot of potential with this geothermal in our future. And that it's the green energy is the wave of the future. There's lots of tax base and revenue in geothermal. So I don't know, once again, we need to clean our forests up, we need to have our biomass plant, but we also need to have our geothermal opportunities explored.
Well, the purpose of the biomass plant that's out there is to kind of do both and utilize the geothermal we have and boost it with the biomass. So it's not one or the other.
It's got geothermal there, yeah, I understand that. So this is kind of a quandary.
But I think what this bill here is trying to do is to give the geothermal interests in Southern California a leg up at the expense of all the rest of us. And I'm not adverse to geothermal. I mean, we've been, and our resource is probably the third hottest spot in the state. The area down by the geysers in Lake County, that area has.
That's depleting.
Well, but that's been the primary
I know.
focus statewide.
Yeah.
And the geothermal resources in the south obviously have potential. But we've been on the map over the last 30, 40 years. What this here does is basically, craps on the rest of the state in the favor of one particular group. And I think that's the issue that Brian's been fighting. He talked about it when he was here for his town hall meeting. And, so I think we need to recognize what the consequence. So if this bill goes through, not only is our geothermal not given the time of day, neither is our wood waste. And so we're a double-edged loser with this bill. And that's, I mean, if you've been following the photos, I've actually been watching, you can go online and you can watch the assembly committees and the Senate committees, the assembly floor, the Senate floor. You can watch their meetings either live or you can go back and watch rebroadcasts of it. And so this bill has been really, I mean, pardon the pun, it's been a lot of hot water down there in terms of generating it, so.
Okay. Aaron?
Yeah, and to kind of tie into what Jim was saying, you know, that, yes, the power plant out there employs 30 people, but you also have all the loggers and truck drivers,
Oh, yeah.
et cetera, that come in.
Oh, yeah.
You have the water quality issue that comes in, the water release that comes in. Even though there's just a window plant here, north end of the county, you've got all the chips and the loggers up there that can send their stuff to Vernon as well. And so, I mean, I think this is huge coming in, and I think we need to support it.
If you can reactivate it, I mean, we've got the power plant over in Westwood that shut down years ago that could possibly, be helped by it.
And before I'm sorry, I tried to do Sheriff a favor, but I overlooked the fact that the Honey Lake Valley wasn't time certain. I thought it was just part of the normal agenda, so I'd like to, we've taken comment from the board. I'd like to table this for now, and I'd like to take up the time certain and come back to this item. I think that's what I made a mistake by trying to,
Well, can we finish up that item?
We can finish
Let's
this.
finish this
you
item.
know what, I think it's gonna go on a while. I know Steve has some comment. I'd like to, out of respect, these 1040 people that have been here all morning, I'd like to take up their issue. Okay?
You're the chair.
Thank you.
Good chair.
Okay, so,
Actually, I think we need some people to have to pick up all the rest of it.
all right, sorry, so anyhow, yeah, that's what I get for trying to be helpful. I actually go in reverse. So, let's take up the 1040 time certain Honey Lake Valley Resource Conservation District.
Yes, thank you, Mr. Chairman. Let me catch up to you here if I may. That is item number D5. Thank you very much. As I outlined in my memo, the CAO brought to the board's attention essentially a complaint that was received some weeks ago about the assessment and apportionments associated with the RCD, and the complaint being that basically the RCD was not complying with its legal obligations. And I think it was Supervisor Chapman that asked me in particular to address this issue, and I think the rest of the board concurred. Essentially asking this board, or advising this board, what its obligations are, what its rights are in terms of levying the tax that the auditor presents to it associated with the collection of the water master service fees that's done each year. And so I sought to do that in my memo to you dated July 9, and basically the sum and substance of it is if the RCD presents a properly certified assessment and apportionment to the auditor before August 15, she shall enroll those, and when it's presented to this board for levy, this board shall levy those fees. And that was essentially the conclusion that I reached. Interestingly, that's no different than the conclusion that she reached a couple of years before when the issue was brought up once before. And so there really is no discretion, as I can conclude, in terms of whether these fees are levied or not. That doesn't mean, though, that there's not some due process available for the users on the river, the decreed right holders, to object to a proposed apportionment. As outlined in my memo to you, there is specific reference in the decree from 2007, which substituted the RCD in place of the Department of Water Resources as the water master. and it specifically says that the RCD is to propose and approve a budget by June 1 of each year. If I recall, it's June 1. But that notice of the apportionments, the assessment and apportionments is to be sent to each of the users by June 15. And thereafter, each of those users has a 2-week window within which to lodge an objection with the Superior Court that rendered the decree. In this case, it would be the Lassen Superior Court. And that objection shall be heard as best as possible before the August 10 date, so that any change to the apportionments based on an objection could be then reflected in that year's apportionments. And so there is a mechanism built into the decree, and so there is a due process component afforded to the users in that regard. The problem has been, and anyways, I hope I answered your question. Simply put, when the RCD presents to us a properly certified assessment with apportionments, the obligation of the auditor is to enroll it, and I believe the obligation of this board is to levy it. And I don't think that we have any discretion under the law. That assumes proper certification.
But the magic date is the June 15th.
No, the magic date is August 15, as I understand it. This,
And the court sets August 10th as kind of a cutoff for
yes,
appeals to the August 15th act.
But,
it sets the August 10 date as a date by which they shall have heard and decided, should have heard and decided, any objections lodged in the court.
But if they don't, by August 10th, whatever was pre-existing
Stands.
stands.
And if there's a decision that's held over until the next year, then there'll be a change in the next year's apportionment to reflect that later decision.
on the, where you say that wherever the budget with the apportionment shall be served by mail on the water right holders by June 15th.
Yes.
Yeah, that was the date, what I was referring to, but it doesn't appear that that's being done, is that correct?
Well, my understanding from the complaint is that the users were notified as to what the total amount of the budget was going to be, but not their individual apportionments.
By June 15th?
By June 15th. Now, here's the rub. The decree requires that, but the code does not. So there's no remedy in the code for a failure to do that. At best, it's something for which a user could object,
The only remedy you have is to appeal to the court because.
lodge an objection.
Yeah, and that's what that says. And that's why, this came before us before, but it was after all the fact, it was retroactive, and there was no way you could go back and undo it. And none of us knew the answer, so that's why when the issue came up again early this year, I wanted to, because there's still time between now and August 10th. So if the parties that, from what I read here, if the parties are agreed, have any recourse, they have to appeal to the Superior Court and get a resolution or direction or intervention of the Superior Court prior to August 10th of this year in order to affect the apportionments that would be applied by the auditor on August 15th.
Correct.
And
Now, interestingly,
but
there
if the
was
court-
such an objection filed this year.
Right, but if the court waits until October to address the issue, it can and will, because it's the dominant body, but the implementation of that would take place in next year's apportionment.
And that's correct. I'm sorry, Supervisor Hammond. You should note, and it was listed in my memo to the board, that kind of in the last minutes of my draft in the memo, I became aware of the proposition that an actual objection had been lodged.
Right.
So it appears, I don't know the basis necessarily of the objection, but one has been advanced, and, I'm left to say that,
Constituents have appealed to this body to intervene on their behalf in a process that they feel that they are not being properly served. What this memo tells us is we don't have the power to intervene, but the courts do.
quite right, The RCD is an autonomous entity, and it is the RCD to which those, and the court is the body where you go for the due process on that issue, sir.
That was the question that I felt that we needed to have addressed, so that the constituents who have the concern can be given a proper answer.
Yes, sir.
For those in the audience, the way the meeting will first, are gonna take questions by the board on the county council's report, and then we'll go to the public and you'll have opportunity to bring your questions. Is there any other questions by board members of the county council's report? Aaron?
Bob, even though there has been a case filed with Superior Court, do you know if it even, if the objection being filed, does it pertain to this topic we're talking about today, or do you even know?
Oh, I think so, but the objection, I don't recall the specifics of it, if they were even listed on there. But my guess would be that the objection was premised upon the fact that the users weren't notified of what their respective apportionments were. And that seems fair to me. You know, you're being asked to either accept what the RCD is saying your share is, what you're being billed for, but when you're not told what that is, how are you to object or not? And so I think an objection was lodged based on that premise, that they weren't told. And the court decree says they're to be told, and it doesn't appear that they weren't. In fact, I got an email confirmation as listed in the memo from, I think, the secretary of the district that confirmed that they weren't told, and in fact it said that, well, you'll figure it out when you get your tax bill. And
Is that contempt of court when they do that?
you know, that's a great question. What I didn't know is, and it'd be up to a judge to decide, is whether the failure of the RCD to perform its obligation like it is supposed to, by June 1 approving the budget, June 15 sending a notice to users, and including in that notice the assessment and the apportionment, whether or not that's just a failure on their part, so you're not going to get to collect your fees, or if it also constitutes a contempt of court. That would be ultimately up to a judge to decide. I think a fair argument. If I was a lawyer standing in front of a court and I was arguing that, I think I might like my position if I was arguing in favor of contempt of court.
The timing of these things just doesn't seem right. So you get notice that you get an assessment, but the audit isn't due in June, but the audit isn't due until August 15th. So where do you know,
Well,
where
wait,
the finances?
apples and oranges. And what I mean by that is as follows. The assessment and apportionments are an estimated cost for the district to conduct its operations for the coming year.
Right, I get that.
Okay,
I get that.
all right.
And I know they have a budget, and I believe that budget's due in June also.
I believe so, yes.
So if there's questions about the budget, then they get assessed, and it's not audited until August 15th, and the objections are due by August 10th.
My understanding of the audit would be that that would be for the past year's financial activities, not the coming year's financial
It is, but
activities.
that's what the budget's for. But I mean, then what if the budget's, the audit discloses some discrepancies, and then then what?
It's hard for me to speculate based on what you're presenting, sir.
Just the timing of the stuff doesn't seem right to me.
Okay. Is there any other questions of county council report of board members before we go to the public? Okay, so at this time we'll take public comment. I don't have any speaker cards, so I'll go by raising hands. Mr. Trask, you had your hand up a while
Could we
ago.
ask specific questions of the attorney before we do this? Because of the
Hold on a second. Okay. I'm gonna have Mr. Trask come, and when you come up, you can ask whatever questions you'd like to the attorney or. I'll call you next, John.
Yes, Bob was right.
Good morning.
Good morning to you, Jim.
You would hope it.
I'm sorry, what?
Mike Trask.
No, what'd you say before that?
I said you were right.
Oh, sorry. I
On a
apologize.
certain aspects, you left a few things out.
It's quite possible.
It's not only to us to be notified by June 15th, it is also the Superior Court of Lassen County.
Yes, quite right. I concur.
And that's where the rub has been the last several years, that you've seen my face here, not that you guys want to see it any more than what you have to, but the RCD never filed it with the court, per Richard's request for me to take it to the court, that it was a court issue. But the court would not accept it, because RCD never filed anything with the court to complain or whatever against. So this is the first opportunity that we've had since 2007 in order to file a complaint with the court over
See,
this matter.
And I've heard this reference before, that the court would not accept a complaint to be filed on the issue. And I'm one of those guys, I'm going to claim being from Missouri at that point. You're going to have to show me that first for me to accept that proposition, that a court who's in the business of receiving complaints all day long and twice on Sundays doesn't accept a formal complaint.
I'll get a letter
Okay.
from Mary at the court if
Fair
that's what this board wants. But the court clerks are the ones that told us that you cannot file the complaint unless there has been something filed with the court to complain against. So, and that's why this year, since they submitted one, finally, we did our court paperwork to it. I came here in February and I gave all the rigmarole from 2007 on to Richard there, and I have never got an answer back, even with the letter that I gave to the board for RCD appointing their own board members. Mr. Crabtree, the county council at the time, sent a letter out to the RCD telling them that they had no authority to appoint their own board members. And that's never been answered, that I've never seen an answer to, but yet they've been appointing their own board members.
I was asked to address today the issue of the levying of the taxes, and I'm happy to answer any questions associated with that. We didn't agendize anything else, I wasn't asked to present on that issue. If the board wants me to look at that issue, I think it was looked at already there. I saw a memo recently on it. Happy to deal with that, but it's not noticed for today, regrettably. And so-
Well, anyway, for the budget thing, that's our complaint that we've had for years, or what, is that it's been done illegal, and there were several years there that this board was not even notified, but yet they still withdrew our money. So if you guys are supposed to approve what the auditor's office does, you'd think that you guys would get notified of what's going on, but the proof in the pudding that I got from the auditor's office, you guys weren't even notified 2, 3, 4 years there out of there.
You're saying that taxes were, RCD presented taxes to the auditor, which she enrolled and then presented, or didn't present to this board, and they were collected from you?
Correct.
Okay. Do you know which year, sir?
Yeah, I gave it all to Richard. I can go back through it again and bring it in again, but I gave it all to Richard back in February.
Okay.
The auditor disagreed, for what it's worth.
Well, I can bring in her original paperwork that she gave me. And there's not even copies of it with the letterhead from the signed board members or the president or chairman of the board of RCD to the auditor. It's from Mr. White, or the previous water master, Keith, and they're not the actual water master. All they are is a deputy, but they're the ones submitting the paperwork for collection of the fees.
But on the issue that you present, which is that this taxes were levied against citizens, property holders.
Correct.
Taxes were levied for this water master service fee, were not approved by this board. That's an easy thing to check. I mean, it's simply a function of looking at the minutes of this board's activities around the same time frame in the years that you identify. I would think that would be.
Because in the paperwork that was sent to the auditor, it has CC'd on there to everybody that's supposed to get a copy, and this board was not copied. What the letterhead or anything from assessment or anything from the RCD.
All right, thanks, Mike. thank you. John Richard?
I
think
apologize, no,
you,
please continue.
Did you want to speak in?
He's certainly has something to say.
Did you want to speak, though? You had your
Oh,
hand
yes,
up.
I do, but Mr. Burns was trying to say something.
No, I just wanted to say, I don't know, I wasn't here during that period of time, sitting in this capacity. Sounds like somebody was.
If I could add, and this may be splitting a hair, I think the requirement that Mr. Trask was referring to about the board notification is that the chair of the board is who it's CC'd to. And, you know, just because there may be a document that shows that it's CC'd to a particular person does not necessarily mean that that person received the document. Because I know in my conversation with him, and it dates back to 2011 when I last served as chair, the document showed it was CC'd, this, you know, a portion of this definitive document was CC'd to the chair of the Board of Supervisors. And I sat as the chair that year, and I never received such a document. I'm not saying that one wasn't maybe intended to, but somewhere in the system it probably had been intercepted. But to my knowledge, you know, the chair is not functioning as an individual, but functioning as a representative as the board as a whole. And maybe it was received by some office, but I never was able to ascertain who received it on behalf of the board. But I know as chair of the board, I did not receive that document that supposedly was sent. And I think that's part of the process, or the problem with the process as you try to sort all this stuff out, so.
Maybe I'm misunderstanding, because as I understood Mr. Trask, I thought the suggestion was that notwithstanding whether a copy is provided to the chair at the
Or
same
to the
time that
courts,
it's sent to the auditor
or to
and
the
to the
courts,
courts,
yeah.
that this board as a body, that it wasn't noticed and agendized and never passed upon. That's what I understood the comment to be.
Yeah. Yeah, I mean, it was never an item that was of discussion by the board or presented to the board or the board became intimately knowledgeable of as a document. I mean, there are probably a lot of documents that we as board members should be receiving, not just on this issue, but on a myriad of issues. And a lot of times people just assume, that's why it's sometimes difficult to have a conversation. Because I think what initiated this, I received a phone call one night from Mr. Trask, and he was pretty animated about, what was, and I'm sitting there like totally clueless, because the documents and the other things that, and he's looking at saying, well, you're listed here as somebody. I'm going like, well, that may be so. I'm not saying that people can't do that, but that doesn't necessarily mean that that document. So I was like totally at a disadvantage in the conversation, because it took me a while to sort through and figure out really what, it probably was a few months later we had a follow-up conversation. That conversation I actually understood what he was talking about from 3 or 4 months before, because it took that much time to kind of gather the information. So it was difficult to have a conversation with somebody in which you don't have the tools to converse.
4277 of the water code is pretty plain, and it says that the Board of Supervisors shall annually, at the time of levying county taxes, levy on the land within the county and within the water master service area apportionment sufficient to raise the amount certified by the department, RCD. And so simply CCing a copy isn't sufficient. It has to be approved by this board, period, as I view it.
And I don't recall that's ever been the case.
I think that an auditor may chime in here too. I think that occurs at the time that the board levies all taxes at the time of passage of the budget.
But when we pass the budget and do that, is there a document like that included in the pile of documents that we're voting on? I mean, I don't think you're gonna find that in the record very often. I don't recall.
I believe there's a levying of the $1 tax rate, and whether or not it's, in the past, it's been assumed that that language, whatever it is,
It may be
applies
assumed
to
that that
the.
language does apply to it. Does that mean that the board is intimately knowledgeable of that document as being part of the record?
Certainly didn't suggest that.
No.
I'm under the impression that the actual apportionments ought to be part of the record.
Well,
Of this board.
I would think it would be and should be, but I'm just stating, I don't think it has been
I don't know the answer to that.
historically.
Council, is this any different than a fire district, a school district? I mean, those taxes are all collected through the auditors, and obviously we don't approve all those.
Oh, but yes, I believe you do at the time that you approve all of the county taxes each year. Sir?
It's just a rubber stamp approval, though. I mean,
The difference between the fire districts and those, they don't have a list of all their, like the property owners in the district. But this water master thing is kind of separate. There's an actual list of these are the people and this is the amount they're going to be apportioned. So by reference, that document, needs to be part of the file, but I don't think that file, the board has ever gotten that included in their file. Our action may, has a broad brush